Allahabad High Court Judge Justice Yashwant Varma, who found himself at the heart of controversy after wads of burnt cash were reportedly discovered at his residence in March this year, has finally moved the Supreme Court, challenging the findings of the final report of the Inhouse committee, which indicted him of misconduct serious enough to warrant his removal. Notably, the sitting judge's plea before the Supreme Court comes days before the beginning of the Parliament's monsoon session on July 21st. What is significant about this year's session is that the BJP-led central government is likely to move an impeachment motion for the judge's removal. This step is in consonance with former Chief Justice of India Sanjeev Khanna's suggestion to remove him from the constitutional office. Based on the three-member panel report, CJI Khanna had sent his recommendation on 8th May to the President and the Prime Minister to act in accordance with the law against Justice Varma. This was done after the High Court judge refused to step down as advised by CJI Khanna. In this video, I, Khadija Khan, will explain the key points of arguments that Justice Varma has made in his petition before the Supreme Court while requesting it to quash the inquiry panel report and seeking a declaration that CJI Khanna's 8th May recommendation is unconstitutional. But first, let's break down the in-house panel report which implicated him. On March 22nd, the former Chief Justice of India Sanjeev Khanna had set up a three-member panel which included Punjab and Haryana High Court Chief Justice Sheel Nagu, along with Chief Justice of the Himachal Pradesh High Court G.S. Sandhawalia and another judge of the Karnataka High Court Anu Sivaraman. This committee was entrusted with the task of carrying out an in-house procedure which involves taking remedial action against judges who by their acts of omission or commission have failed to follow the accepted values of judicial life. This mechanism was introduced in 1999 by the Supreme Court and it was further strengthened in 2014. Such a mechanism was evolved in order to include some additional safeguards when it comes to registering criminal complaints against sitting High Court or Supreme Court judges. It also requires the approval of the CJI when lodging an FIR against a judge and disallows the police or enforcement agencies from proceeding against them arbitrarily. The three-member panel came out with its final report on 3rd May, which basically said that there was sufficient substance in the allegations against the judge. It also stated that the judge had indulged in misconduct by failing to answer where the cash came from on his premises. This misconduct, according to the committee, was serious enough to initiate proceedings for his removal. The report even went so far as to say that the morning after the fire, someone had removed the remnants of the burnt currency from his outhouse and that this fact was known to Justice Varma. A little over a month later, the judge has now approached the Supreme Court challenging the panel's findings against him as untenable and based on unjustified interferences rather than evidence. So let us take a look at Justice Varma's defense in this case. No personal hearing. After this report came out, CJI Khanna had advised the judge to either resign or seek voluntary retirement by the evening of 6 June, failing which he would have to inform the competent authorities to initiate action for his removal. Instead of heeding to this request, Justice Varma asked for adequate time to review the final report and pointed out that in the past, in-house procedures allowed for personal hearings before the CJI and other senior-most judges of the Supreme Court. However, he argues in his petition that he was not allowed this opportunity for any personal hearing in the matter, nor did he receive any response from the CJI. Unblemished judicial career. In his plea, Justice Varma also argued that he is a sitting judge of the Allahabad High Court with an unblemished judicial career spanning 11 years. Elevated from the bar as an additional judge in 2014, he was later promoted to a permanent judge of the High Court in 2016. 5 years later in 2021, he was transferred to the Delhi High Court where he served until March this year. However, shortly after the fire that occurred at his official Tughlaq Crescent residence's outhouse on March 15th, which led to the discovery of a huge stack of cash there, The judge was repatriated or transferred back to his parent High Court, which is Allahabad High Court, in April this year. Why didn't the officials seize the alleged cash? One of the things pointed out by Justice Varma in his plea was that while extinguishing the fire, officials of the Delhi Fire Services and the Delhi Police found burnt currency in his house. Despite this, however, the officials did not seize the alleged cash. They did not prepare a panchnama or otherwise memorialize their discovery in any manner known to the law, he said. He also pointed out that certain photos or videos were privately taken by some of these officers, which even formed a basis for the events that followed, and that the inquiry panel should have gone into these details. Gaps in findings. Justice Varma also argues that on 12th March, which was 3 days before the fire took place, his wife and him had left for Madhya Pradesh for the holy holidays. He added that he was not even present at the official residence when the incident occurred or when the burnt cash was allegedly discovered at his home. The essential purpose behind the committee was to test the veracity or the truthfulness of the allegations against Justice Varma. Instead, it failed to answer when, how, and by whom the cash was placed in the outhouse, he said. The report also did not delve into vital aspects like whether the cash was genuine or not, what was the cause of the fire, and whether the judge was personally responsible for removing the remaining currency after the fire. The mere discovery of cash provides no conclusive resolution. It remains essential to determine whose cash and how much was discovered. These aspects bear directly on the severity of the allegations and equally on the potential for an orchestrated scandal, he said. In-house procedure usurps Parliament's authority. The in-house procedure, which was adopted through a 1999 full court resolution of the Supreme Court, is a mechanism to handle complaints against judges and to preserve judicial independence while maintaining public faith. In his petition, the judge questioned the basis of such a probe panel, arguing that the procedure unjustifiably extends beyond the intended scope of self-regulation and fact-finding. By recommending the removal of a judge from a constitutional office, the in-house mechanism creates a parallel and extra-constitutional process, which is a deviation from the legislative framework provided in the Constitution. The power to remove a judge is exclusively vested with the Parliament, and the administrative action by the judiciary is a violation of the doctrine of separation of powers, which is a facet of the basic structure of the Constitution, he said. Virtually condemning the in-house procedure, the judge argued that the judiciary cannot assume the role of a legislature by recommending the removal of sitting judges. Media trial. Finally, the judge also said that an unprecedented public disclosure of the unverified allegations against him by way of a press release issued by the Supreme Court on March 22nd subjected him to a media trial. This resulted in irreparable damage to his personal reputation and career as a judicial officer too. And that brings us to an end of today's segment. For more legal updates, keep watching The Print.